Please observe them. All right, let's get going. Please stand. Thank you.
Who's lead? Who's leading?
I am.
Good morning, Ms. Lo. Good morning, Ms. Van den Heever.
Good morning, Chairperson, Commissioners.
Thank you.
If I may just use the opportunity, I'm sitting together with one of my learned juniors, Ms. Fatima Misi. She's a member of the Johannesburg Bar and Legal Practice Council. I've got a second junior that's battling to make it through security, Lena Brighton, who will soon join us. Also, just for the record, in addition to the attorney that's on record, a new attorney was brought on to specifically because of the various matters that we're dealing with to assist us in dealing with the work of the Commission. They are present. It's for lawyer attorneys. They're sitting behind. Thank you very much.
Thank you. Good morning to you too, Mr. Matlala.
Good morning, Chairperson.
Thank you.
Morning, Chair, morning, Commissioners. Today we start the scheduled start of Mr. Matlala's testimony before the Commission. Chair, we have now brought to the Commissioner's attention, there is an issue we will have to engage on before Mr. Matlala begins his testimony. But for housekeeping purposes, I request that we initiate the proceedings formally in a sense that Mr. Matlala be sworn in. We submit his statement into record, and then both Ms. Van der Heever and us will address you on the issues that are to be raised. And for the record, Mr. Matlala's testimony will be conducted by myself, together with Ms. Hassim. Thank you.
Thank you.
Chairperson, good morning again. I have taken note of what my learned friend says. There's been quite a number of issues that has occurred behind the scenes, which is not necessary at this stage, I think, to engage yourself and your fellow commissioners on. My learned friends for the Commission and myself has been dealing with some of these issues. The suggestion that the process be started as my learned friend Marcelo has right now suggested, I've indicated to her that because of the time issues, I've not had an opportunity to take specific instructions from the client, as we've had a bit of a different approach in this matter. Unfortunately, due to the time constraints and due to the fact that I could not get the opportunity to consult with the client in privacy, we had to come here so that your work can start this morning. So I would like the opportunity to, in fact, consult with my client on the issue that was suggested by my learned friend.
Please, maybe I missed, what is that issue? Is it, are you referring to whether Mr. Matlala's statement should be read after he has been sworn in? Is that the issue? Indeed, because of, as I said, we've got a very specific approach. Maybe just for the record, my learned friends will confirm it. We've been engaging them off and on, and especially during the course of last week and over the weekend, about the manner in which we think the matter should be dealt with. We're on the same page at this point in time. However, due to some of the issues that's unfolded over the weekend, again, as I said, it's not necessary for me to place it on record. I want to consult with the client on the suggestion by my learned friend, in other words, that he be sworn in and that he deals with the affidavit that was submitted, because of the approach that we as a team have taken. I think he's got the right to understand what the Commission wants, the evidence leaders wants to do at this point in time, and I need to engage him on what or how he needs to deal with it at this point in time, in the absence of us being able to properly deal with our approach to his evidence as we foresaw it and the way we've planned it.
Oh, thank you, Ms. Van Heever. For that purpose, 10 minutes should be enough.
It should be ample. Thank you,
Yes.
Chairperson.
Let's adjourn then and resume at 9:45.
Thank you.
Can someone please let Ms. van der hear for that we are here?
Yes, Chair.
As arranged.
I confirm that they've gone through to fetch Ms. van der Heever to present herself.
All right.
Thank you.
We'll sit and wait then. Thank you, Ms. Zello. Yes, Ms. van der Heever. We always, at this commission, we always make a point of keeping time. Please, for
Yes,
the future,
Chairperson,
please.
You know that I've always been on time when
Yes.
it comes to dealing with the business of the Commission.
Yes.
It is unfortunately so that the issues that I have to discuss with him is much more complex than just a question of yes or no. It involves legal issues, and the client, of course, asks questions to understand the legal issues. And I can't just leave it there. I need to explain to him what the issues are. So I will ask that you excuse us that we were late, but please take it from us that it was necessary that we deal with it as to the best of our ability within the very limited time that we've got. Where we are right now is not as because of the doing of my client at all. Okay. Maybe whilst I am addressing you, Chairperson, my client has agreed to the statement being read out. I need to place on record that the following has occurred in the interim. We have been furnished with quite voluminous extra information. Let me call it information for purposes. So the information that needs to be canvassed and dealt with and that relates inter alia to the 10.6 has increased almost tenfold. Last count, and that was before we got a further email last night, the volume was far exceeding 2,000 pages. It's common course between us and the evidence leaders that we were only served with bundles yesterday afternoon. We could only then take it in. We had no opportunity whatsoever to canvass the content of these bundles. It's common course between us that it far exceeds the, let's say, what was contained in the Rule 3.3s, and there's quite an array of new information in it. That information, inter alia, relates to issues that was canvassed in the 10.6 that we, I respectfully submit, now have an opportunity or should deal with in a supplementary fashion with our affidavit. There's information contained in there that was never within the purview of my client. That's the first issue. We have also, I've had a discussion with my learned friend, and I'm raising this ahead of my client being sworn in and dealing because it would guide the way forward. We do intend to take issue on quite a number of legal aspects. I've approached my learned friends and we've come to an agreement that those legal issues, we wish to raise it almost as a point in limine because we believe that it will be, it can dispose of where we're going further in this matter. I'm not going to go into the detail of that. I have indicated to them that we are busy with, also because of course what my learned friends have told us, their approach to the matter. We've decided that the best way to deal with it is to file the supplementary affidavit and deal with the legal issues in it. That would give the evidence leaders the opportunity to answer to the legal issues that we raise. We will, of course, if necessary, because it's legal, supplement it if necessary, draft heads of argument and then deal with those issues or argue those issues and for you then to make a ruling on it. Our approach was that we file the supplementary affidavit and that it be dealt with together with the affidavit that's currently before you, because some of the rights that he's laying claim to in this affidavit has no legal basis. In other words, it's not explained to you as the commissioners why he is claiming this right. So the legal basis for it is not in there. There was good reason, and I don't think it's in the interest of anybody that I, at this point, deal with why it was not, the basis of it was not laid at that point. My learned friends have indicated that if he reads out the affidavit, they're not going to ask him any questions on it. My concern is that if, for instance, you as the commissioners wish to ask points in clarification and it relates to legal points, you know, what do we do there? We say that our supplementary affidavit will take care of any concerns that you might have or any questions that you might have based on, let's say, the points in limine. I want to call it that because I think it's a good way of explaining that. Let's say the client says, I'm not dealing with any questions pertaining to it, to person X that you've listed in your 10.6. I say, as an example, I'm a suspect in a matter that relates to person X that's named there. We think, as I've indicated to you, that the way to deal with it is then to deal with that issue in the supplementary affidavit with a proper legal basis and then explaining factually why we say we are a suspect so that everybody is on the same page. And as where I started off is that you then make your ruling and say, you're not a suspect, you have to answer questions pertaining to witness X. Or you uphold our point and say, well, in law I agree, you are a suspect and on this issue. In other words, the evidence leaders cannot traverse anything pertaining to witness X. That is, in short, where we are. So my suggestion, or my respectful submission, and not in the way you interpret respectful submission, Chairperson, is that we be given, because we've already got dates in mind and we agreed on timelines, that you afford us the opportunity to file the supplementary affidavit so that you can read it in conjunction with the affidavit that's before you for a full and complete understanding of the legal and factual basis on which the rights that the client claims in there is, or how he claims it on. That would also give us an opportunity, as I say, and that's the second leg of it, to now deal with totally new matter pertaining to the, let's call it the Annexure A, that very long list, where the state, sorry, not the state, the commission, the evidence leaders has now come up and included documentation or references to those people in the bundle. It also gives the client the opportunity to deal with those and respond to that. Thank you very much.
Thank you, Ms. Van Heerfer. At the beginning, I thought I understood you to say that Mr. Matlala, I assume after advice from you, has agreed that his statement should be read into the record. No. And I understood that to mean that's going to happen now. But as you went on and mentioned the supplementary affidavit, I got confused, and especially once you said that the two statements should then be read in conjunction with each other. So I got lost, and I do not know whether you are saying the statement that we have now should not be read, and that the two, that is this statement and the supplementary statement, should be read together at a later stage.
So maybe I'm
confused.
Maybe I should clarify. That is our first preference, that we deal with it in the way, and that is what I pitched or I proposed to my learned friends, that you wait, let's file our supplementary affidavit. We intend to file it within days, because we need the opportunity to canvass all the material. There's literally, you can see, I think there's 4 boxes here on top of each other with material.
So your alternative, which is my understanding of what you said at the beginning, so the alternative
is he reads it in without any questions of clarification, and that is parked until such time as the supplementary affidavit is filed, because that would take care of any questions of clarifications that you as the commissioners may have. My learned friends, I've got no issue with. They've already said we're not going to ask questions. My concern is if you, for instance, wish to raise and say, oh, you say that you're a suspect in this matter, explain it to us. We do not believe that it would be fair to the client that it be dealt with in that fashion. We say, give us the opportunity to file the supplementary affidavit, then you can read it as one, because we will cross-reference the answers, and it would shorten the proceedings in any event. It would most probably answer 99% of any questions that you might have initially on clarification issues, because it will be dealt with factually and legally.
I have not conferred with my co-commissioners, but I do not see any problems with clarity-seeking questions that are purely on factual issues. So I hope your submission does not go to the extent of saying no such questions of clarity. That is not even on pure, simple factual issues. I hope you are not going that far.
Chairperson, of course, you always have, I know your act, I know your rules, I know your regulations. You are entitled to ask questions of clarification.
Yes, all right.
But those questions of clarification, we respectfully submit, must be dealt with in conjunction with the rights that we claim. And that's why I said, I think it will make it easier for everybody, and I apologize for repeating this point.
Yeah.
If we file the supplementary, then we're all on the same page, an argument goes to the heart of what is contained there. So if you were, for instance, to ask a question and clarification, and we say that, you know, you cannot do that because of the legal issues, then that brings to an end. But if I could just go one step further, that's why I've also indicated to you, we believe that it would be in the interest of everybody concerned and the business, I respectfully submit, of the Commission, if we deal with the what I call the points in limine first, because that will be the positive of anything that goes forward. Because if you uphold our submissions that we make or the points we raised, then it's clear for everybody you cannot go there. But if you don't, yes, then we are where we are.
Thank you. I would rather we start with a reading of the statement, and we will ask clarity-seeking questions. And if you happen to have issues with those, you can raise the issue at the relevant time. There are two issues I want to raise with Ms. Sillo. Did you want to say something further?
No, Chairperson, I just want to say, so if I understand your ruling, is
yes.
read in the affidavit?
Yes.
At this point?
At this point, yes. Oh, two issues. We have received quite a number of these complaints by witnesses that they have been furnished with voluminous documents at the last minute. You might just want to address us on that, please. And then, secondly, an experience we have had is, I forget who the witness was, but the name is not important anyway, where I think the bundles went up to, or rather were in excess of 4,000 pages. But for practical purposes, what the chief evidence leader, Mr. Shaskalson, did was to say to the witnesses' legal representatives, we are only going to use X number of pages in these bundles. And that number of pages was only in the hundreds. It did not even reach 1,000 pages. So we have been told that the bundles here in Mr. Matlala's matter are in excess of 2,000 pages. If you are in a position practically to say to Ms. van den Heever, of the 2,000 plus pages, we are only going to use X number of pages, please do that. Thank you.
Thank you, Chair. And before I do so, if I may, with your leave, address a fundamental error that I think Ms. van den Heever made, which is, to her understanding, the evidence leaders had undertaken not to ask questions of clarification. it was, to the extent that she so understood that was a complete misunderstanding on our part, because that effectively would be treating Mr. Matlala differently from all other witnesses. The process that we had suggested when it's his own time to narrate his story is that he's subjected to questions of clarification both from the commissioners, and we have no control over that, and that we too may have questions of clarification, and we leave it at that. So I just wanted for the record to correct that to the extent that she understood that to be our position, then we either miscommunicated or she misunderstood us. Turning then to the issues that the chair has posed to me directly. Yes, Chair, the bundles were unfortunately delivered very late. As Ms. van der Heever points out, we've been in engagement for an extended period, including the whole of last week. And it was hoped that in the course of last week, at least the electronic bundle would be available. That too was late. The system somehow was not coping. In large part because, Chair, when you postponed the appearance of Mr. Matlala, it was for the 1st of September. Mr. Matlala then presented himself in his criminal trial, and the judge set out a program for that particular trial, which impacted the intended date of the 1st of September. So we had to change everything and ensure that we are able to have access to Mr. Matlala for purposes of this commission without necessarily prejudicing him in the criminal trial. And the only option available to us was then to bring it forward by 2 weeks. In that period, our systems were preparing for other witnesses until the 1st. And it was not the most ideal, but where we landed was that even the electronic bundle was issued late. Then, as luck would have it, Murphy's Law crept in. That itself, it had problems, because when you click on the document that the index suggests is the document being presented, then the document comes out blank. So there have just been just a comedy of errors regarding the bundles. So Ms. van der Heever is quite correct that they were given late. Even we, as the evidence leaders, received ours very late, including the last batch by yesterday, last night. So we do appreciate the position that it places her and her client in, and that they do require time to apply their minds to the bundle. And we have no challenge in them being afforded the opportunity to do so. We believe that they are so entitled. The bundles are voluminous, and yes, they're in excess, I think, a total of 2,000. There is a slight difference, however. When the Rule 3 notices were served on Mr. Matlala, they were, as is standard, served together with excerpts from the relevant witnesses, where it is, our interpretation was that Mr. Matlala was being implicated. So he got only excerpts, transcripts and statements and documents from the evidence of the testimonies of the witnesses that appeared. The approach adopted in the compilation of the exhibit bundle was slightly different, which is to provide, if it's an excerpt from a statement, to provide the full statement so that appropriate context is taken when Mr. Matlala has to consider. So that automatically increased the number. So it's very easy to identify the documents, to say when you were given a Rule 3, you were given excerpts from this particular document. We've now made the full document available to you. And that full document will, of course, traverse issues that are wholly irrelevant to this particular witness, because the excerpts would have done that. But for context purposes, we decided to provide everything. The same goes for the chats, WhatsApp chats that were relied upon. He was previously given chats relied upon in evidence, but now there's been a fuller disclosure of the chats for a certain period, and that added to the volume of paper. Thirdly, it is possible to direct Ms. van der Heever on the relevant portions for purposes of our engagement with Mr. Matlala that we'll be relying on, so that they don't necessarily have to troll through all 2,000 pages. So we can do that. It's a question of how we've got proposals in that respect. It's a question of where we land in terms of dates, because if we are given other dates that are not successive, we are able to identify for purposes of a particular date what topics will be covered and therefore what documents will be relevant from the exhibit bundle. And so to the next date and the third if possible. If there are successive dates, then we might as well just do a complete sweep of the bundle and say these are the documents that are going to be relevant. I will confirm for the record that everything that was given to him in terms of the Rule 3s will be relevant for purposes of preparation. Thank you, Chair.
Thank you.
Chairperson, I appreciate what my learned friend has placed on record. The proposal that we be told, let's say for a particular date, this is what's relevant, might be a bit problematic because our client is, unlike most witnesses that appeared here, not a man roaming the streets. We need access. We need that access is exceptionally limited.
May I make this request, Ms. van den Heever? Let's start with a statement. And once we are done with it, may those logistical issues be discussed between you and Ms. Long.
I'm quite happy that we do that. Thank you, Chair.
Thank you, thank you. Mr. Matlala, will you be swearing or affirming?
I'll be swearing.
Can you please state your full names for the record?
Say that again.
Please state your full names for the record.
Musi Matlala.
Do you swear that the evidence you are going to give is the truth, the whole truth, nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you, Chair. And I haven't had the opportunity. Good morning, Mr. Matlala.
Good morning, Commissioner.
Mr. Matlala, you should have by you a fairly small white file. And
I think the witness's file has been taken away. We'll just go on, look at it electronically. It's just going to be a bit of an issue pertaining to the paginated numbers, but I've handed mine over just for purposes of getting away, moving along.
taken by who so that we can track it down?
I think the attorneys took the boxes with, but it's not an issue. Let's just move on. You can use mine in the interim.
That's fine.
Thank you.
I hope that the file you've been given accords with our paginated version. But let's start with the cover. It should bear your name on the spine and read Regulation 10.6 notice, statement and annexure. Is that what you have?
Yeah, it is.
Thank you. Now, you do confirm that you have filed a statement in response to a request by the Commission to address certain specified questions that were posed to you. Is that correct?
Yes, I do.
I would like you to, on that file, then turn to page 8 and have regard to the contents of the document appearing from page 8. It runs until page 17. And it has in the trim lines at page 8 the word affidavit, and it purports to be your affidavit. And if you go to page 17, this is a document, an affidavit sworn to by yourself on the 2nd day of August 2026 and bears a signature above the word deponent. Do you confirm that's your signature and that the details I have read are correct?
Yes, I confirm.
Now, attached to this statement, if you go further from page 18, is a 2-page document that is referred to in this particular statement as annexure VM1, and that would start at page 18. Do you so confirm?
Yes, I do.
And you stand by the contents of this statement as we sit here now?
Yes, I do.
Just to give you a sense of how we normally run our processes here in the Commission, as a start, we give the witness an opportunity to speak to the statement that they have submitted. They have a choice of summarizing issues or reading the statement into the record as we go along, or in fact, a bit of both. During that time, you can expect not to be engaged or the facts that you attest to not be contradicted either by the evidence leaders or the commissioners. So you have a free run with the statement. You must, however, anticipate questions which we call clarification questions. The clarification questions will be based on what is contained in the statement, either in a particular paragraph or a paragraph considered in the context of another paragraph, just so you clarify what your eventual position is as regards a particular fact. Do you understand?
Yes, I do.
So when we start, then you will have the opportunity to relate your story as you choose, and as I said, you may read or summarize. Secondly, the structure of your statement is such that you respond specifically to the issues raised in the Regulation 10.6 notice that was served upon you. So you do so with reference to the specific paragraphs in the 10.6 notice. In your statement, you deal with your response to the specific issue in a certain paragraph, but you do not indicate what was asked of you. That's correct?
Yes, that's correct.
So to facilitate the appreciation of your testimony by future readers, where you indicate that you are responding to a particular paragraph, like you say, at paragraph 2.1.1, please allow me an opportunity to read into the record what was stated in paragraph 2.1.1, and then we deal with your response there too. Would that work for you?
Oh, yeah, it will.
Thank you. So if then we may start at paragraph 8, and before we do so, you should have page 8. We should have from page 1 to 7 the actual 10.6 notice that you had received. Please confirm that's what you have.
Yes, I do have.
Then each time we have to go back to the 10.6, that is the 10.6 I'll be referring to, and you are welcome to go to it just to satisfy yourself that I am reading into the record correctly what is set out in the 10.6.
Okay.
I invite you then to deal with your statement starting from page 8. I think it makes sense that you perhaps read the beginning and the first 4 paragraphs, and because from the 5th paragraph you are now responding, you pause thereafter, and then I will read into the record paragraph 2.1.1 of the 10.6 notice, and then we take it from there. Thank you.
I should start reading.
Please start reading, whichever works best for you, yes.
1 to 4, paragraphs 1 to 4.
I'm an adult businessman currently incarcerated as a remand detainee and awaiting trial. The facts deposed in this affidavit, save for where otherwise stated or indicated, are within my personal knowledge and are, to the best of my belief, both true and correct. I confirm that I was served with a notice in terms of Regulation 10.6 of the regulations of the Commission, and therefore I depose to this affidavit in response to the notice referred to herein. Where I make submissions of law, I do so on the advice of my legal representatives, which are advice I verily believe to be correct.
Thank you for that. You then have a heading at paragraph 2.1.1. That is paragraph 2.1.1 of the 10.6 notice, which, as I indicated, starts from your page 1. If we could then refer to page 2, the first 2 paragraphs are the standard preliminary introductory comments to the notice itself. But you were requested from paragraph 2.1 to provide comprehensive background information, including, and you start with your paragraph 2.1.1, and the question to you was whether you have previously been convicted of any offense by a court of law in South Africa, and if so, full details including dates of conviction and nature of the offenses. You deal with that at paragraph 5. Please read your paragraph 5.
I confirm that I have previous conviction of housebreaking and theft to which I was sentenced to an effective 8-year prison term. I served 18 months of this sentence and I was subsequently released.
We then turn to the next question and the 10.6 at 2.1.2, where you were asked whether you have ever been charged of any offense and charges were later withdrawn against you. You are required to provide details of the charges and dates when charges were withdrawn. You respond to that particular request at paragraph 6.
I can confirm that I was previously charged with offenses that were later withdrawn. I attach here to as Annexure VM1 a list of the offenses that I was charged with, which were later withdrawn.
And you confirm that the VM1 you reference there is the document appearing from page 18?
Yes, I
page
do.
18 and page 19?
Yes, I do.
These are the matters you were previously charged with, but all of which were subsequently withdrawn. Is that
Yes,
correct?
Yes.
Okay. The next question to you was at paragraph 2.1.3, asking whether you are currently facing any charges, and if so, the nature of those charges and dates when you were charged. You deal with that question at paragraph 7 of your statement, if you could read that.
I confirm that I'm currently facing 2 separate pending matters as set out below. I have a pending case in the High Court of South Africa, Johannesburg, under the case number SS98/2025. I was arrested and charged by members of the PKTT on the 14th of day of May 2025. I've been indicted on charges of attempted murder and money laundering, which trial commenced on the 20th day of July 2026 and shall run until the 18th day of September 2026. I'm also facing a case that is pending before the Specialized Commercial Crimes Court under case number A16/212/26. I was formally charged with corruption and money laundering on the 24th day of March 2026. I place on record that this matter is with respect to a health risk tender awarded by SAPS to Medicare 2420 Pty Limited. I confirm that the time of submission of the bid and the subsequent award of the tender, I was the sole director of Medicare 24.
Thank you. At paragraphs 8 and 9, you respond to the question posed at paragraph 2.1.4, which reads thus: when and how you first became involved in the security business and the health sectors. If you could then read your response, which is reflected at paragraphs 8 and 9.
I first became involved in the security business on or during 2017. I became a director of CAT Protection and Security Pty Ltd Trading as CAT VIP Protection with registration number 2017/177122/07. I became involved in the health sector by means of registering my company to the Central Supply Database in order to participate in the provision of services to government entities. By virtue of being registered on the CSD, my company will receive requests for quotation from the Department of Health, as this is the sector in which we had indicated as our field of trade on the CSD. It is then that company will provide the requested quotations and thereafter, upon success, provide the requested services.
Before we leave paragraphs 8 and 9, just to clarify, at paragraph 8, you deal with the company CAT VIP Protection and you give the registration number. At 9, you deal with involvement in the healthcare sector and you say you did so by means of registering your company. Just to clarify, is this the same company you registered or is this a different company?
No, it's not. It's not the same company. It's not the same
It's a different company?
Yes.
Would you recall off the top of your head the name of the company?
Yes, I do.
Yes, if you could provide that, please.
Black AK Trading and Suppliers.
Sorry, I missed that. Please say that.
Black
Yes,
AK Trading and Suppliers.
thank you. And would you have a recollection of when that registration on the central supplier database took place?
I'll say around 2018.
2018, thank you for that.
Yeah, ma'am.
And I do accept that you're speaking off the top of your head.
Yes.
So, thank you. We then, in your statement, moved to the question that was posed at paragraph 2.1.5, which was whether you have other business ventures outside of the security and health business, and you provided response at paragraph 10.
I place on record that I do not have any other businesses outside of the security and health sector.
And if I may just clarify, your participation in the security and health sectors is specifically through the two companies you have named. Are there any other?
Yes. Yes.
Just the two?
Yes.
Is it not three? Medicare, cat protection, and Black AK?
Well,
Or are we only dealing with health and not security?
no, I'm dealing with both health and security.
So it would be three.
The Medicare 2420.
Medicare, cat protection services, and Black AK trading and supplies.
That's for the health sector. And then CAT VIP. Do you understand the
Yes,
question,
I do.
Mr. Matlala?
Yes, I do.
So you confirm that's just
Yeah,
the three
yes,
companies
yes.
you reference at paragraph 7.2, 8, and 9. You had no other companies through which you participated in the health and security
Yes, I
services sectors.
Yes.
Thank you. Then we turn our attention to the question that was posed at paragraph 2.1.6 of the notice, and the question required you to provide an explanation of your interactions or business engagements with state entities such as the South African Police Service, SAPS, and Ekurhuleni Municipal Police Department, EMPD. You are required to provide details of any companies or organizations in which you have an interest which conducted business with state entities. These details should include their establishment, business activities directors, and any joint ventures or contracts within the state. Your response to that extensive request is in your paragraph 11 at page 10. And it's got under the heading SAPS, and at your paragraph 11, you address the issue, your relationship with EMPD. So let's first deal with your paragraph 11, which is specifically directed to your dealings with SAPS.
My company, Medicare, was previously contracted by SAPS to provide health and risk-related services. I place on record that the Medicare tender has since been terminated. As already alluded to above, I'm currently facing a criminal charge which is pending before the Specialized Commercial Crimes Court with respect to the Medicare tender. In light of the current pending criminal charges referred to herein, I'm unable to comment further on this matter in that I do not wish to give evidence that may lead or self-incrimination, and therefore I claim the privilege against self-incrimination. However, I do, wish to assist the Commission as best as possible. Safe to say that I am unable to comment on matters that are sub judice. I'm in any event entitled to be presumed innocent until proven guilty. I'm advised that this is a well-established legal principle which affords protection to accused persons in criminal matters. The exercise of my right to claim privilege against self-incrimination should not be viewed as an obstruction or unwillingness to assist the Commission. Please.
Before we turn to the issue of EMPD, just what you have stated in paragraph 11, if you are able to explain the extent to which you invoke that privilege, is it entirely in respect of your engagements and dealings with SAPS, or are you confining yourself specifically to the Medicare 24 contract?
It's in relation with the Medicare 24 contract.
Specifically, you confine yourself there too.
And anything that will have to be connected with the Medicare 24 contract.
Anything that will be connected with that contract?
Yeah, of course,
Okay.
yes.
Then, from paragraph 12 rather, you then deal with the issue of EMPD.
Yes.
If you could read your response.
I place on record that none of my companies were ever awarded contracts by EMPD, and that the only business that was concluded was for no financial gain, in terms of which we through one of my companies, CAT VIP Protection, provided security services to former Mayor Tanya Campbell.
And on that issue, you haven't provided it, but are you able to, if it exists, to provide any documentation in respect of the security services you provided to the former mayor? Would you have any documentation in respect thereto at hand?
No, I do not have any documentation.
Okay. Then you go to the issues.
Sorry, Mr. Matlala, we have evidence, I hope I'm not mistaken, that your company provided security at a state of the city address in Eguruleni.
Yes.
Was that a separate incident, or is it what you are referring to here?
Yeah, this is what I'm referring to.
Oh, thank you.
Thank you, Chair. And before perhaps we leave that point, when we do get to the point of engaging you, I trust you'll be able to give more detail regarding specifically the security services you provided to the former mayor at a later time.
Of course.
Okay, thank you. Then at paragraph 2.1.7, the notice required you, with regards to the subs contract awarded to Tshwane Medicare 24, to explain the circumstances in which you came to submit a tender for the subs health risk management contract, including any engagements with subs members, whether or not they were involved in the bid evaluation adjudication process, the management of the contract once you were awarded the tender, and any gifts, sponsorships, gratification, favors that you provided to any member of subs after you were awarded the tender. That's reflected at paragraph 2.1.7. You deal with the contents of that at paragraph 13 at page 8, if you could read that.
As already alluded to above, the subs and Medicare contract is a matter in which I have been criminally charged and currently attending court, and as such, I'm unable to comment on the question posed on the paragraph under reply, and the basis is that I do not wish to incriminate myself. The Medicare subs tender is a subject of a criminal court case, as already alluded to above. I remain an accused in that matter together with my company, and as such, evidence is still to be led in an open court with respect to this matter. I am entitled to be presumed innocent until proven guilty, and also not to answer self-incriminating questions, especially on such a complex matter that the state has already preferred charges against me.
That would then conclude the list of questions asked of you under paragraph 2.1 of the 10.6 notice. The notice then moved on to paragraph 2.2, which had about 7 sub-questions. You deal with that from your paragraph 14 and into paragraph 15. The questions set out in paragraph 2.2 are lengthy, but basically they required you to explain or provide an explanation on the history or relationship, whether direct or indirect, with certain persons listed in the Schedule A to the 10.6 notice. And you were requested, as you provide that information, to answer specific questions relating to such relationships set out in paragraphs 2.2.1 to paragraph 2.2.7. Your response, as I say, starts from paragraph 14, And if you could read that into the record. And then from paragraph 15, under different 4 sub-paragraphs, you deal with your relationships with different persons. So when the time comes, we will take it in terms of each individual identified, and then we'll read that particular portion into the record. For the moment, I invite you to deal with paragraph 14.
The following.
So are you not going to do what you've been doing, which is to read, so you won't read 2.2.1?
The 2.2, the question really is at 2.2, to explain your history and or relationship, direct or indirect, with certain listed officials. Then it required him, in his response, to provide the following information: when and how you met each individual, the nature and description of the relationship, the nature and extent of and frequency of communications, the nature, extent, and frequency of physical meetings, whether you have exchanged information with such persons, and whether he has been offered gifts, gratification, money, and whether he has been requested or been offered any favors by any of these individuals. So the questions listed from 2.2.1 is in respect of each individual listed in Annexure A. And that Annexure A appears from page 7.
Okay, all right.
Thank you,
Thank you.
So if you could then, as I said, deal with your paragraph 14.
The following SAPS officials are my co-accused in the criminal case with respect to the SAPS Medicare tender, and as such, I'm unable to respond to the questions posed relating to them on the basis that I do not wish to incriminate myself. As already alluded to above, the criminal case is still pending and awaiting adjudication in court. General Fani Masemola, Brigadier Rachel Majeng, Brigadier Alfuios Timkosi Ngema, Brigadier Patrick Natengwe, Brigadier Kesti Yonker, Brigadier Petunia Riabetu Lenono, Brigadier Onika Offensive Tlwadi, Colonel Anton Paulson, Colonel Natsenge Johannes Monyai, Colonel Nonjabudo Nomfundo Mgadi, Colonel Tumisho Nehemiah Maleka, Captain Brian Neville Cartwright, and Major General Busisiwe Precious Temba.
You then, from paragraph 15, deal specifically with 4 people. At 15.1, you address matters of your relationship with Minister Senzo Mchunu. At 15.2, you deal with your relationship, if any, with General Pahlani. At 15.6, misnumbered as 14, at 15.6 is your relationship with General Nhlanhla Mkhwanazi, Lieutenant General Nhlanhla Mkhwanazi. At 15.3, Lieutenant General Molefe Fani. And at 15.4, with Major General Feroz Khan. And that concludes your testimony in regard to the relationships, the relationships you have with the various persons listed at Annexure A. You confirm that?
Yes, I confirm.
Now, looking at your paragraph 14, you have listed 13 persons there that you say are your co-accused in the Medicare 24 contract.
Yes.
And you request, in extending your privilege, that you not be required to comment or testify about any relationship you may have with any one of them.
Of course.
So, if we go to page 7, though, I realize that if one has regard to the 13 that you request that you not be questioned about because they are your co-accused in the Medicare 24 contract, we'll look at those you deal with at paragraph 15. It still does not conclude the list at page 7. Would you please go to page 7 of that file?
I'm on it.
I'll give you an example. Your item 5 requested you to speak to any relationship you may have with Lieutenant General Shadrach Sibia. Item 8 requested the same of Lieutenant General Sintu Mule. 9 with former General Tema. 10 Major General Leseja Sinona, and so it goes. So there are persons in Annexure A that you have not included in your statement. Why is that?
Yeah, these are the people that will be added in the supplementary affidavit.
Why did they not form part of the statement? Because you do not explain, at least as far as I can see, in your statement
They are not
that you will, if I may just complete this, that you will be addressing the remainder of the persons identified in Annexure A at a later stage in a supplementary affidavit.
Yes, I was just only referring to my co-accused. So these people here are not my co-accused.
No, sorry, perhaps I wasn't very clear. I'm saying, if we look at the people at 14, you say these are your co-accused.
Yes.
But then you go further at 15, you deal with others who are not your co-accused.
On paragraph 15.
From paragraph 15, 15.1 to 15.4. As I read them out, it's Minister Senzo Mchunu, that's not your co-accused.
Yes.
Former General Pashani, Lieutenant General Mkwanazi, Lieutenant General Fani, and Major General Feroz Khan. So, besides the fact that you don't deal with the ones you say are your co-accused, which is a different issue, you appear to have made a selection from Annexure A as to which relationship to talk about. And I point out that, for instance, you completely ignored the request that you talk to your relationship with Lieutenant General Shadrach Sibia, who's listed under 5, to Lieutenant General Kosi Sentumule, listed under 6, and Major General Sinona, under 10, former General Sandra Tema, under 9, Major General Shibiri, under 12. So my question was, besides the fact that I hear you will not deal with your relationship with your co-accused, you have gone further to make a selection to deal with only 5 of the remaining persons whose names appear on Annexure 5, and have chosen to ignore completely the other persons, with no explanation in your statement as to why that is the case. And I'm inviting you to explain to the commissioners why that is the case.
I will say it's because these people, in my supplementary affidavit, it will explain further why I didn't include them now here. So because there are some reasons, I did that deliberately because I have reasons why I did not include them. But only those reasons will be found in my supplementary affidavit.
Are you in a position to share the reasons now and the detail then of the relationship you have with the respective persons to be included in your supplementary? The reasons I'm requesting is why they don't form part of this particular statement. And then you don't have to elaborate on the relationship you have with each one of them.
It will have to do with the recordings which I'm disputing. So I did not want to add them now because I have to now dive deep and explain why I'm saying I'm disputing the recordings, which we still have the transcripts that we still need to transcribe again because of some of them are unofficial transcripts.
So then if I understand you correctly, and I don't want to misunderstand you, anyone appearing at page 7 that you have not dealt with, it's your submission that they are to some extent impacted by or involved in the recordings that you intend to dispute.
Yes.
Is that the
Yes.
basis? I hear you. And that will become apparent when you submit your supplementary statement.
Ms. Sillo,
Chair.
are you not in a position to itemize all of the names that have been excluded? Because what you've done now is to give examples.
Yes, we are able to.
If it will take time.
No, it won't, Chair. Perhaps
right,
I'm thinking of the
please.
best way to do it.
All right.
It would be to read the listed paragraph 7, and then we start with where he has itemized at paragraph 14, and then I'll relate it to the item number. Mm-hmm. Then I will call out those that are dealt with in paragraph 15, and then it will become apparent then who else is remaining. Mm-hmm. So it will just be a quick exercise of. So if we.
And sorry, Commissioner, to disturb. I actually wanted to ask clarity because I see here there is on number 20 on page 7.
Yes.
number 27, there's the Sergeant Zungu.
Yes.
So I don't know, because I do not know Sergeant Zungu, but I know Captain Zungu. So I don't know whether the commission made a mistake or what. So I couldn't comment on this, not knowing whether it's a mistake or not.
I'll try and clarify that for you.
Okay.
So I will highlight Sergeant or Captain Zungu as a specific case.
Okay.
And it's because it was unclear to you, as I understand it, who the commission was referencing. So I'll come back to you with clarity, and then you can deal with that
fine, thanks.
in the supplementary. Chair, then the quick exercise. I think the best way to go about it is to use Mr. Matlala's statement at paragraph 14. At 14.1, he deals with General Masemula. Now, the request that he deal with General Masemula is item 3 on page 7. It's followed by Brigadier Rachel Macheng, and Rachel Macheng, Brigadier Macheng, is item 14 at page 7. The next is Brigadier Alpheus Teminkosi Ngema, and that is item 15 at page 7. That's followed by Brigadier Kirsty Jonker, that's item 17. 14.7, he deals with Brigadier Onika Ufenze Kwayele, that's item 19. That's followed by Colonel Anton Paulson, that's item 20. 14.9, it's Colonel Natsenge Johannes Munyai, that's item 21. Followed by Colonel Nonjabulo Nomfundo Mgadi, it's item 22. I was then requested to comment on his relationship with Colonel Tumisho Nehemiah Maleka, that's 24, item 24 at page 7. Followed by Captain Brian Neville Cartwright, that's item 25. And lastly, Major General Busisiwe Temba. That's item 13. Item 13 at page 7. I note that at paragraph 14.13, Mr. Matlala refers to the Major General as Temba with an H. Page 7 is Demba without an H, so we accept that perhaps our spelling may have been wrong. He intends to, it's correct, Mr. Matlala, you intended to talk about the person listed in item 13 of page 7, notwithstanding the difference in the spelling of the name.
Honestly, I don't know his surname, so I don't know whether it's a spelling error or not. I don't know how to pronounce her.
No, that's quite fine, and I do accept that the spelling error may be on our part, but at least it's the same person that we are dealing with. If we then, Chair, move to...
Sorry, I think I missed two names. Did you include both items 23 and 24, Colonel Maleka and Lieutenant Colonel Maluleke?
Yes, Nehemiah Maleka, who's 14.1, is included. It's item 23.
Oh, yeah.
Yes.
And 24?
Maluleke, I had...
Not.
Maluleke is not listed, is not part of his paragraph 14.
All right, thank you. Thank you.
Now, paragraph 15 then involves other persons, the first being Minister Senzo Mkunu, and the request in that respect is item 1 of the page 7. The next is General Pashani. And item 4 on page 7. Thereafter, it's followed by Lieutenant General Mkwanazi, that's item 6. And Lieutenant General Mulife Fani, that's item 7. And lastly, Major General Feroz Khan, that's item 11. So that would, on my estimation, leave If we go then page 7, it will leave item 5, Lieutenant General Shadrach Sibia. It will leave out item 8, Lieutenant General Kosi Simtumule. Item 9, former General Sandra Tema. Item 10, Major General Lesija Sinona. Item 12, Major General Richard Shibiri. Item 16, Brigadier Patrick Netengwe. 18, Brigadier Petunia Reabedzi Lenono.
Sorry, Netengwe is 14.4.
Oh, the error is mine. Yes, it's quite good. Thank you, Commissioner. Then that takes us to 18. 18 is dealt with, yes, at item 14.6. So after Major General Shibiri, then we would jump to 24, Lieutenant Colonel Maluleke. Yes, we've got Malika. And then Sergeant or Captain Zungu, as the witness has stated, and Commissioner Julius Mukwanazi at item 28. Those are the persons that he has not addressed in the statement or his relationship with them.
Ms. Zillo, it might be I missed it. Item 2 and 26.
Yes, item, indeed. 26 would be Faningosi. That's quite, I confused that with Mulefe Fani. That would be correct.
And did you mention item 2?
I miscounted it as a matter, somebody he had dealt with in his statement. The commissioner is quite correct.
Thank you.
Chairperson,
Yes.
I do feel compelled, maybe as client is not legally trained, to just highlight the following issues. In addition to what the client has said, I was not the deponent, or I didn't assist with the drafting of this affidavit, but I was consulted on issues relating thereto. The persons that were left off also relates to IDAC. There are certain investigations conducted by IDAC, it was going to be dealt with in the supplementary affidavit. There was information that the attorneys endeavored to obtain from IDAC that, put it this way, that they battled to get, but we're dealing with it in a different way. So the legal basis is not only based on the statement that's at issue, but it relates to investigations that were conducted by IDAC. And I think I'm going to stop there because we do intend to basically also set out for you the legal basis as to why these names cannot be dealt with also vis-a-vis IDAC's investigations. And then specifically, I can also mention in respect of the last person, I think it's General Konazi from the EMPD, there's certain further information. It all relates to the issue of suspect, the legal definition of a suspect, etc., and your rights afforded to you as a suspect. I just wanted to place this on record. May I please you?
Thank you. Thank you, Ms. Van der.
Thank you, Chair. So we understand the reason why then some of the people who've been left out on the list were left out. We accept that they will then be addressed in the supplementary statement to be filed, and we shall pick it up from there when that statement is filed. Let's then turn our attention, Mr. Matlala, to your paragraph 15, where you then deal with the 5 people. At 15.1, you recall that the request to you had been to explain the history and relationship you maintain with the specific persons listed at page 7, and to give the details as to the nature and extent and frequency of your communication, etc. You deal at 15.1 with your relationship with Minister Mtunu, or if there is any, if you could then address yourself to your paragraph 15.1.
I place on record that I do not have any relationship with Minister Senzo Mchunu. I have never met Minister Mchunu and have had no interactions with him, nor have I been at any gatherings where he was present. It suffices to say that I do not know Minister Mchunu.
And just a question of clarification here. You say you have had no interactions, I take it, with personal interactions.
Yes.
Have you had any interactions on your behalf? Have there been any interactions on your behalf with Minister Mchunu to the best of your knowledge?
Yes.
Initiated by you? Have you ever requested anyone to engage with him on your behalf?
No, it was only during when we had to confirm whether we know each other. There's a letter that I sent to, it was sent, I think, to the IDEC committee.
Yes.
So it's that interaction that I'm referring to.
So that's the interaction you had with him? Are you able
Not
to...
with him directly.
Oh, yes? Please clarify.
Not with him directly.
Through who?
Through the attorney.
Okay. The attorney being his attorney or your attorney?
My attorney and his attorneys.
Okay. Sorry? Now you have specified the interactions you had with Minister Mchunu through your attorneys, and you referenced a particular letter you submitted to, or that was submitted to Parliament, and you said this was through your respective attorneys, both yourself and Minister Mchunu's. Have you had any other dealings or interactions with him through interactions by others?
No.
None.
No.
Then if we go over... Yes,
Before
please.
you, Mr. Mchunu's foundation, have you had any dealings with it?
No, nothing.
Thank you, Commissioner. Now, perhaps because you were requested at 2.2.5, when you speak of any particular individual, to indicate whether you have exchanged information with them. At 2.2.6, whether you have given or offered any gifts, gratification, money, sponsorship, favors to any of these individuals. Now, confining ourselves to Minister Mchunu, if you look at paragraph 2.2.6 of the notice, do you confirm that you have not taken any step that constitutes an offer of gift or sponsorship to Mr. Mchunu, whether directly or indirectly? Is that your position?
No, I've never, yes.
Okay. If then I can invite us to page 13. At page 13, you deal the same questions, but now in respect of former General Khomotso Phahlane. You deal with that at 15.2.
I place on record that I know General Phahlane. I'm unable to recall how many times I have met with him, and place on record that these meetings were, to the best of my knowledge and belief at the time, when he was no longer within the employ of the subs. I confirm that I have no business dealings with General Phahlane, nor have I ever asked for any favors from him or offered him any gratifications.
In light of your response in regard to General Phahlane, may I then ask you, insofar as Minister Mchunu is concerned, specifically, whether you have ever asked of him any favors?
From General Phahlane?
No, Mr. Mchunu, I'm going back because when you speak of General Phahlane, you specifically say you've never asked for any favors from him or offered him any gratifications. That is a claim you don't make in respect of Mr. Mchunu. So my question to you is whether you have ever asked of any favor of Minister Mchunu.
No, I have never asked any favors from him.
We then, you then, at paragraph 15.6, deal with your relationship with Lieutenant General Nhlanhla Mkhwanazi. If you could read that into the record.
I place on record that I know and have, I know and have on one occasion met Lieutenant General Mkhwanazi. I do not have any relationship with him.
Are you in a position to describe very briefly, even just highlights, this meeting on this one occasion? Are you able to provide any detail?
I cannot provide any details because it has to do with the case that I'm attending in Pretoria for Medicare tender.
Sorry, please say that again.
I'm saying I cannot provide any details because my meeting with General Mkhwanazi, it has to do with the tender that I had with SAPS.
Okay.
Which now I'm attending court and I'm charged for that matter.
So if I understand you correctly, then your meeting in that occasion you reference involved the Medicare 24 tender?
Yes.
Did it involve any other issue besides the Medicare 24 tender?
No, it has to do with Medicare 24 tender.
Your voice tends to drop sometimes, or maybe
Oh,
my
sorry.
hearing is not
Miss-
what it
yeah,
should be.
I'll try to speak next to the speaker.
You can pull them closer to you if more comfortable. Thank you. Yes, no, my question had been on that particular one occasion because you say you've met with him only once. I hear that you say that meeting involved or related to the Medicare 24 contract, which you say is part of the ongoing criminal trial.
Yes.
My question was whether or not you discussed any other matters outside the Medicare 24 contract, and if so, what those were.
Yeah, there is something that we discussed except the Medicare 24 tender.
Are you able to shed light on what was discussed?
Maybe, again, Chairperson, this particular issue, I want to request for a number of reasons that it be parked. We intend to bring, if necessary, again in law, an application to the Commission to deal with that issue differently. So at this point, I respectfully submit that for reasons that we've also disclosed to the evidence leaders, I do not think it's pertinent or prudent at this point to deal with this issue. We will deal with it in the supplementary affidavit together with a specifically application as to how we wish to deal with that aspect, because the client's already indicated to you that there's a relation to the Medicare contract and it flows from there. Thank you very much.
But Mr. Matlala has just said that it's not related to the Medicare 24 contract.
It is indirectly related to it. As I said, my client is not an attorney or an advocate. He doesn't understand the legal, the finer points of the law in as much as how you indicate direct or indirect or related to.
Chair, my challenge is if we approach matters on that basis, then anything that was discussed on that one occasion, including any potential Christmas gifts, cannot be discussed, simply because the Medicare 24 contract happened to be discussed in that meeting. Now, Mr. Matlala has specifically, as the chair points out, that there were other matters discussed that are unrelated to Medicare 24. Now, if Ms. van der Heever wants the matter to be parked, as she suggests, the least she could do, I would suggest, is to advance a legal basis to the commissioners for why this matter should be parked. I do not see, even if she were able to, I do not see why the witness cannot comment just in general on the topics that were discussed and the detail to be unpacked in the supplementary statement. Thank you, Chair.
Chairperson, on that issue, if necessary, I will file a substantive application to deal with it and ask that that application be heard in camera. Thank you.
I just want to be sure, is the point the simple one that the other issues that were discussed which Mr. Matlala says are not related to Medicare 24, but which you say are indirectly related to Medicare 24, that Mr. Matlala is claiming the privilege not to incriminate himself. Is that your point, Ms. van den Heever?
My point actually goes further, Chairperson, and that's why I say, with the greatest of respect, allow us the opportunity on that issue alone to set it out, file a substantive application, and set out to you the reasons as to why we believe that should not be dealt with in an open forum.
But in broad and general terms, why can't we hear now what the extension beyond the privilege is, in broad general terms, not any detail?
Chairperson, then I'm going to ask that I just deal with this issue with the client during tea time, and that we then come back after tea time to that particular issue. I need to take an instruction on him as to exactly how he feels comfortable in me addressing you on that issue. As I said, please understand it clearly, this is not to interfere with the flow of what we're busy with. But I also have my client's interest at heart when I address this issue. But I'm quite willing to have a quick discussion with him during the tea period and come back to this to see how we can deal with it.
Perhaps in the interest of time, Ms. Illo, for now, let's just park the issue and revisit it when we come back after the tea.
I'm happy to do so, and I see perhaps it is about that tea time, but if I could just conclude on paragraph 15, and then we'll revert to this issue. Except to go on record and say, Mr. Matlala has got a full appreciation of the fact that the other issues that were discussed bear no bearing on the Medicare 24 contract, and that's the understanding that he gave to the commission, to the commissioners in response to a question, and he is very clear about that. But we shall park the matter and we will pick it up after tea. For the moment then, Mr. Matlala, let's go to your paragraph 15.3. This time you are addressing your relationship with Lieutenant General Fanny Molefe. If you could read the contents of 15.3 into the record.
I place on record that I do not have any relationship with Lieutenant General Molefe Fanny. I have never met him and have had no interactions with him, nor have I been at any gatherings where he was present.
And that will then lead us to your paragraph 15.4, where you specifically then deal with your relationship with Major General Khan.
I place on record that I do not have any relationship with Major General Khan. I have never met him and have had no interactions with him, nor have I been at any gatherings where he was present. It suffices to say that I do not know him.
And I take it that if one has regard to paragraph 2.2 of the notice of the 10-6 notice, that insofar as both Lieutenant General Fanny Molefe and Major General Feroz Khan, you cannot speak to the issues raised in paragraphs 2.2.1 to 2.2.7, because you, as you say, you do not know them at all, and therefore the issues that are raised in those subparagraphs do not arise in regard to them. Is that your position?
Yes, of course.
Thank you.
Let us adjourn and resume at 11:35.
Settle down. All right, we are ready to resume proceedings. It's 11:34. Again, please make sure that your cell phones are off, that they are quiet, your devices. We don't want them disturbing the proceedings. Thank you.
Ms. Van den Heeven?
Thank you, Chairperson, for the indulgence. I did discuss it with the client. He's going to add something to the answer that he's given. The previous point, however, stays that there is an aspect we will deal in the supplementary affidavit, but the other aspect he will deal with in public.
Let us hear you, Mr. Matlala, and whether or not there will be follow-up questions, we'll see based on the response that you give. You still remember the question by Ms. Sildo was whether any other issues other than issues relating to the Medicaid 24 contract were discussed with the Lieutenant General Mkhwanazi. Yeah. Let's start there, and I think you then...
I confirm, Chair. I think that's the best place to start.
Yes.
And as the Chair has pointed out, there might be follow-up questions based on his answer. Thank you.
Yeah, other than the Medicare tender, we also discussed the warrant that they had by then of my arrest. So, but the warrant is for the case that I'm currently charged with in the Johannesburg High Court. So I wouldn't want to go further in respect of that matter because of his currently pending in court.
Is that so? Those are the only two issues.
The other issues, like I discussed with my counsel, they said they will make a submission, and then I don't know how they will deal with it, but she just explained now that it will have to have an application for that.
But Mr. Matlala, I think the antecedent question before we get to that point on which you receive legal advice, the antecedent question is, are those other issues related to the Medicare 24 contract or the matters in respect of which you have been charged?
Yes, it's not Medicare 24 tender, it's the other matter that I'm charged with. However, I'm saying I will still comment more on, regarding that matter, but I needed to make a submission with my counsel, and then she will advise further on how we will deal with that.
I'm not sure I understand. I want to be sure, are you talking about other matters in addition to the one about the warrant? It's
No.
Medicare 24, it's the warrant of arrest.
Yes.
Are there additional matters?
No, there's no other additional matters.
All right, thank you.
So then, if I understand you correctly, what was discussed on that one occasion you met with Lieutenant General Mkhwanazi were the two issues: matters relating to the Medicare 24 contract. That's one.
Yes.
And secondly, the issue regarding your warrant of arrest.
Yes.
And now you confirm those were the only two issues.
Yes.
Now, on the warrant of arrest, is it, you said the Johannesburg case?
Yes.
The only reference you've made to a Johannesburg case is what's set out in paragraph 7.1
Paragraph 7.1.
of your statement.
7.1.
7.1. Is it that matter, is it in relation to that matter or a different matter?
Can I please check?
Please do.
Chairperson, just to save time, simply put, my instructions are that General Mkhwanazi told the client there's a warrant of arrest out for you. You will be arrested on the matter that is currently parted in the High Court of Johannesburg. I think it's easier that we just place it on record.
Chair, I have challenges. I don't know whether...
I also, even as you started speaking, Ms. Van den Heever, it's Mr. Matlala who's testifying, and let Mr. Matlala respond. 2 questions. You may speak, of course we can never gag you. You may speak if you want to raise an issue. But what you just said, I think, is an evidentiary matter to which it is Mr. Matlala who should respond.
Thank you, Chair, and I think perhaps that we need a cautionary note going forward that in trying to assist the Commission, perhaps Ms. Van den Heever takes particular note of the risk of testifying from the bar, because then it places me in a very difficult position of not knowing whether to invite her into the witness box. My question,
Can you please repeat your question?
my question to Mr. Matlala.
Yes,
Mr. Matlala had said that on the occasion he met with Lieutenant General Mkhwanazi, they discussed 2 distinct issues. The first related and concerned the Medicare 24 contract, on which he says he is currently facing a criminal charge. The second relates to what he calls the warrant of arrest, and he said for the Johannesburg case, and that's where he left it. So I informed Mr. Matlala that on my reading of his statement, the only Johannesburg case referred to in his statement is what's set out in paragraph 7.1. And I sought to establish from him whether it is that case that he references, or is there another Johannesburg case on the basis of which the warrant was discussed.
Yes, I just checked it now. Is this case on 7.1?
It's the same case?
Yes.
Okay.
Can we just get clarity on when and where the meeting took place?
I'm not sure about the date, but it's in 2025. In, I think, around March, but I'm not sure.
And where?
It was in Durban.
And if I then may just follow up on that, who initiated the meeting?
I asked for the meeting.
Now, I understand then that the detail of what was discussed regarding the Medicare 24 contract, for which you invoke your rights as an accused, as well as the discussion around the warrant of arrest in respect of the Johannesburg court case, the detail will be provided in the supplementary statement.
Yes.
And in respect of both, you invoke your right not to self-incriminate.
Yes.
Is that okay? Just checking.
I just ask one more
Yes.
question, sorry. Is this the same meeting where General Senona was present?
Yes, that's correct.
Is that the same one?
Yes.
He's already testified as regards the date and time, so I think he said it was in April.
April.
Yes.
Okay.
Thank you, Commissioner. And you will accept that date of the April because you say it's the one occasion?
Yes.
Okay. This then would lead us to your paragraph 16, starting at the bottom of page 13. And at the bottom of page 13, you respond specifically to what was raised in paragraph 2.3 of the 10.6 notice. Now, in regard to 2.3, you are requested to speak to 5 instances or incidents and to explain your involvement in any one of them. They are listed from 2.3.1 to, in 6, in fact, 2.3.6. You confirm that? That was what was requested of you, 6 separate incidents. If you could just have regard to page 4 of the 10.6.
Page 4, you said 2.3 point?
If we go at page 4 of the
Yes,
10.6 notice.
Yes.
Now we're dealing with paragraph 2.3, If you look at your statement at page 13, you start at the bottom at paragraph 2.3.3, which is a sub of paragraph 2.3 in the notice.
Okay.
You confirm that. And I say, if one has regard to paragraph 2.3 of the notice, 6 separate incidents are referred to there, and you are asked to comment on each one separately and to state your level of involvement in each one of them. You confirm that was what's requested of you?
Yes, I do.
Okay, now looking at then starting your paragraph 16, I see you specifically deal insofar as 2.3 is concerned with paragraph 2.3.3 and 2.3.4. Just for the record, 2.3.3 required you to provide detail of and your involvement in the circumstances in which Sergeant Faninkosi came into possession of your Luxor Africa Bank card. You were required to list all the periods when he had possession of the card and what, when, and for what this card was used for. You deal with that at paragraph 16. You confirm that?
Yes, I do.
Then paragraph 2.3.4 of the notice required you to address the loan of funding agreement entered with Mr. Salim Karim or any of his companies in or about June 2024 or any other date, including a copy of such agreement and the terms thereof. That you deal with at paragraph 17, where you deal with paragraph 2.3.4 of the notice. You confirm?
Yes, I confirm.
Now, I note from your statement that you specifically don't deal with paragraphs 2.3.1, 2.3.2, 2.3.5, and 2.3.6. Now, before we then deal with the matters that you respond to, let's try and address the matters that you choose not to respond to. 2.3.1 required you to speak of your involvement in Major General Khan's disciplinary hearing, including communications with Mr. Mokhotsi regarding Mr. Maluleke's testimony and attempts to bribe him in order for him to change his testimony in favor of Major General Khan. You don't deal with that, the issues raised in that particular sub-paragraph. Is there a reason for that?
Honestly, it's an oversight. I don't have a reason not to deal with this one. I can deal with it now. I'm sorry about this.
If you can deal with it now, we would appreciate if you spoke to it, because this is your moment to respond to the regulation 10.6 as received. So let's start with paragraph 2.3.1. You have looked at it, you have considered it. What can you say as regards what's set out therein, and anything that you may overlook in the process, you will then elaborate on in your supplementary. But for the moment, you can introduce us to any response you have to that question.
So it's in regards with Mr. Maluleka, am I right? 2.3.1.
2.3.1, yes.
Yeah. Yes, Mr. Maluleka, I know him, he was staying at my house. The reason for him to stay at my house, I think he was robbed or something, and he didn't have a place to stay, and then I offered him a place to stay. So he was staying at my house, and as soon as he heard that the police went to my house and to do that first raid, and I've been complaining about the conduct of the police to extent that I even attempted to make an agent high court application to interdict the police from harassment. So I've been sharing these things with him anyway. So there came a point where I don't know who contacted Mr. Maduleka, but he told me that, listen, I've been asked to go and testify against, give testimony in relation to General Khan. So, and then he said, because these people who I requested me to go there and testify, that are the people who went to your house and raid your house. So is there anything that you want me to do in regards with this thing. So, and then I told him that, listen, whatever it is, I've already sorted out my issues with these people. So I don't have anything to do with them anyway. So, but he said to me, he already spoken to some guy, Mr. Mohoti. And Mr. Mohoti asked him to go there and then to testify, but I do not know what he was supposed to say in his testimony. So he wanted my confirmation that, do you really want me to go there and then testify in favor of General Khan? I said, I do not know General Khan anyway, and then even if you do, it won't help me with anything because I already sorted out my problems with the police that were raiding my house. So from what I heard is, I heard it from Mr. Mohoti, that he said to Mr. Mohoti that I'm going to testify in favor of General Khan, but I want you to speak to your people to give me a promotion and some money. So Mohoti showed me the communication between himself and Mr. Matlala. So there was a meeting that they were supposed to have a meeting somewhere. I think it was in a hotel somewhere in Johannesburg. I forgot the name of the hotel. So I asked Mohoti that, okay, did your person did what you said he will do? He said, yes, he did, but he told me that they've even recorded him, I think, because he was asking for promotion and money. So I will say, from the top of my head, that's how I remember about this Mr. Matlala story.
By whether he had done what he had said he would do, were you referring to him testifying at the disciplinary proceedings?
Yes.
So he had said he had testified?
No, not the disciplinary proceedings, I'm sorry. He was going, before he went to testify, he had an appointment with Mr. Mohoti. And then Mr. Mohoti arranged, I don't know with who. They met with those people, and then that's when maybe they were planning to try to come up with how is he going to testify, I think. So during that meeting, that's when he was recorded. Mr. Mohoti told me that they've recorded him, and then he's asking for money and a promotion. I said, then if he's stuck there, then why don't you ask the person that is helping you to give you money? So why are you, that cannot be my problem. So I left it like that, and then.
So when you asked whether Mr. Matlala had done what he had said he would do, were you asking about whether he had made an approach for him to be promoted?
No.
When you asked, has he done what he said he would do, what were you asking about?
I was asking that he said he will testify in favor of General Khan. So I was asking Mr. Mohoti that, did he do that?
Thank you.
Thank you, Chair. And just as a follow-up, considering the issue, which was you were to speak to Major General Khan's disciplinary hearing, and then including communication between Mr. Mohoti and Mr. Matlala, and you've testified as you have. I'm not sure I understand, or I'm clarified in my mind, what evidence could you potentially give at the disciplinary hearing? What evidence were you being requested to provide at the hearing?
I don't know. I will be lying, I don't know.
And you don't know in relation to what aspect of the disciplinary?
What I know is it had to do with General Khan. And then what was the details of the disciplinary hearing, that I don't know.
Besides testifying, what role did you understand was required of you? What role did you understand was expected of you?
Of me?
Yes, in all of this, in all of this.
No, it's not. There was no role. I think Mr. Matlala wanted to do me a favor.
Yes.
Because of he was under the impression that at that point, I'm not in good terms with the police.
Yes.
So then the very same police, they are the same people who asked him to come and testify. So he wanted to do me a favor and then testify in favor of the person that they wanted to discipline, I think.
Okay.
Oh, okay, so maybe then the misunderstanding was mine. You were not being required to go testify.
No, not
That was-
myself.
okay.
No.
Then I think I misheard you.
Now, can I just clarify, Mr. Matlala, the favor that you say you think he wanted to do you a favor?
Yes.
The favor would have been what? That General Khan is acquitted?
Yes.
Okay, thank you.
Can I just, sorry, Mr. Law. Did you speak to Mr. Maluleke when you offered him a place to stay? Who actually spoke to him and arranged a place for him to stay?
I went to see him at the hospital, and then after he got out of the hospital, there's a guy who stays at it's a cottage.
Yes.
So I connected him with that guy, and then he went there.
But he did speak to you,
Who?
Mr. Maluleke.
Yes.
And then you say when there was a raid at your house, you also told him about that.
Yes.
So you spoke to him
Yes.
on at least 2 occasions?
No, couple of times, not two.
Couple of
Couple
times.
of times, yes.
All right, thank you.
Thank you.
And the home where you housed him, where is that?
It's in Pretoria,
Pretoria. Where in Pretoria?
in Mamelodi.
In Mamelodi, your home. Yeah. Oh, all right. Thank you.
Thank you, Chair. That is then in regard to General Khan's disciplinary hearing. Anything else that is relevant to the question posed at 2.3.1?
Not that I can think of, but if I think of something, I will add it in my supplementary
Your
affidavit.
supplement. Noted, thank you. The next question is at 2.3.2, and here you were asked to speak to your involvement in the delivery of Impala to General Sibia and any other forms of gratification you may given to General Sibia. It's at 2.3.2. Once again, that issue is not addressed at all in your statement. Would you like an opportunity to do so now?
Yes, this will also be in my supplementary affidavit because I just heard from the recordings after I've made this affidavit that there's a recording. In that recording, there is I'm mentioning this Impalas in that recording. And then I did not know by then that there was a recording which speaks about such things. So now I have to go back and then make a supplementary affidavit in relation with this Impala story.
I hear you because now you want to engage with the recording itself, whether it's by way of questioning or challenging its correctness or otherwise. That's a separate issue. Mine is you were specifically asked in the 10.6 to speak about the delivery to General Sibia of Impalas and any other form of gratification given to him. So we can confine ourselves to the question as posed. The content of the recording we will deal with in the fullness of time.
Yes, Commissioner, like I said, I do not want to incriminate myself because I know that the recordings are under investigation. And by the time when I made my affidavit, I was not aware of that. So I just heard the recordings after. So I do not want to comment on something which on a later stage will incriminate me.
So that if I understand you correctly, in respect to the question posed at 2.3.2, are you asserting your right against self-incrimination?
Yes.
And what in particular would you be speaking to that places you at risk of self-incrimination insofar as the delivery of Impalas to General Sibia is concerned? I just need to understand the basis upon which you are invoking that. Are you facing criminal charges for that currently?
No, there's investigations.
Yes.
Which it's been said in open court that there is currently investigations going on. So what I will do is I think I will get the transcripts and then of my court proceedings, and then I think I'll need to attach them to my supplementary affidavit.
Can you tell, I asked Ms. Hassim here, perhaps because I don't necessarily know everything. Which court proceedings are you referring to?
The Johannesburg High Court.
Is that the attempted murder case?
Yes.
The
Let me try to clarify this.
Please, if you can.
We asked for the recordings during the pre-trial, and then the state advocate said that no, the recordings, they are not part of that trial, of that case. So it's something else which they are investigating, meaning whatever is in the recordings is under investigation. So hence I'm saying now I do not want to comment on that because I know that it's under investigation.
So if this is for my understanding, is it your attitude that the commission cannot engage you on anything that you suspect is currently under investigation?
Not suspect, something that I know for a fact that is under investigation.
So you cannot be engaged on anything that is currently under investigation?
Yeah, that
whatever the basis of investigation and progress of investigation, is that the attitude you assume?
Yes, I do not want to incriminate myself on that.
Sorry to interrupt, my learned
Yes.
friend. Chairperson, again, this issue of General Sabia, I want to place on record, forms part of the whole IDAC matter that we intend to deal with also in our application as well as in the supplementary affidavit. Thank you very much.
Thank you.
Can I just ask to make sure I understand? You're saying there is an investigating officer who is looking at the question of the delivery of impalas to General Sibia?
I'm saying there is an investigation, the entire recording. So I do not know out of the entire recording which part is investigated, which part is not. But what I'm saying is, in that recording, there is the impala issue in that recording. So I do not know whether it's part of it or not. But what I know is that they're saying that recording itself is under investigation.
So your answer to my question is, you are not saying, as a matter of fact, that there is an investigating officer who is investigating the issue of impalas delivered to General Sibia. That's not what you're saying to us.
I'm not sure about that.
Yeah, you're not saying that as a fact. You see, you're raising, you say you're reluctant to speak to it because you don't
Yes.
want to incriminate yourself.
Yes.
So it's important that we understand the basis of it. Is it just a suspicion that you have that the delivery of impalas is being investigated? It's a suspicion and we have to deal with it on the basis that it's a suspicion, or as a matter of fact, there is an investigator, an investigating officer who is looking at this specific question. It is important to understand which one you're relying on.
What I understand is they said there is an investigation, so they did not specify, because there's a number of issues in that recording, so they did not specify that directly we're investigating this, not this. That I do not know. So I cannot say it's under investigation or not. But what I know is that the entire recording itself, they say they are investigating it. So I do not want to sit here and saying, no, this is under investigation. Which chances are there? Maybe it might not be under investigation, or it might be. I do not know that.
And if it is not under investigation, you would be able
Of course, yes.
to speak to it.
Yes, I will.
Thank you.
And if then I may just follow up on that, you'll be able to make a determination based on the recording itself. Is that what you need to hear in full to understand whether or not there's an investigation, or is there some other exercise we can expect you to undertake to determine whether or not there's an investigation regarding the impala specifically? Where do we land? I'm trying to anticipate what we can expect in your supplementary, because as you say to Commissioner Balo, you don't know whether specifically the issue of impalas is the subject of investigation. You can't say that for a fact.
Yes.
You know that it features in the recording.
Yes.
And you need an opportunity to listen to the recording in its entirety. Did I understand you
No, I'm
correctly?
not saying that.
Okay. Then
I've listened to the
misunderstood.
recording. That's why
Yes.
I'm saying I know that the Impala's issue is part of the recording.
Okay.
I've listened to the recording. I do not know whether the investigating team is also investigating the Impala aspect. I do not know that. What I know is the state advocate said the recordings is under investigation.
Okay.
So which investigation, I cannot tell. I do not know that.
So then it's fair to depart from the premise that when we resume, armed now, by then with your supplementary statement, you will be able to indicate to the commissioners, as a matter of fact, that that particular issue is the subject of ongoing investigations.
I cannot promise that because for me to find out, I have to engage with the investigators then, and I'm currently in custody, so I do not know how I will find a way to find out for sure that they are under investigation or not. I do not know that.
Then, so we leave it on the basis that you will deal with it in the supplementary statement, specifically that issue, and how the commission then deals with what you say in regard to the impalas to General Sibia will be the subject of the legal debate, whether or not you are required to answer thereto. Is that what you are suggesting?
Yes.
Okay.
Can I ask a question? Is it possible to avoid the legal debate by simply inquiring from IDAC whether this specific issue is the subject of investigation? If they say it is not, then as I understand Mr. Matlala, there would be no reason for him not to answer.
Chairperson,
So,
maybe I can deal with
Sorry,
that.
I was not addressing you. Please wait your turn, Ms. Van Heerden. I'm raising it as a possibility. I'm
I
not
hear
saying
that.
that's what must happen.
I hear that. We could do that, except that we run the risk of IDEX saying that it's not subject of our investigation. That does not exclude some other law enforcement subs investigations, for instance. And hence my interest to find out from Mr. Matlala what his understanding is in regard to any investigations concerning the Impala. He should be able to indicate.
Can I do this, sorry, because I wanted you to finish on this issue and then Ms. Van Heerden gets the opportunity. In light of what Ms. Sillo has said, there's no need. I think I'm covered.
But perhaps let me still hear Ms. Van Heerden. It sounded as if you had your ideas on a possible solution. Yes, Ms. Van Heerden?
Chairperson, there's maybe just for the record legally, the issue of suspicion has got an objective and a subjective part. I think that we must all just place this on record. So it's not a question of seeing it very simplistically. That's the first aspect. The second aspect is that when it comes to IDAC, we are in the process and we have been engaging them on certain aspects. So we as officers of the court, that means the legal team, would be able to engage you on that issue itself. It is, I would find it extremely, maybe I should use the word weird, for an accused person who's currently incarcerated to be able to answer the question as to whether there's an investigation on or not. We as legal people normally engage the various authorities that deal with these aspects to establish what the position is with regard to that. But to allay any concerns in that regard, we are busy with this whole issue involving General Sabia and other issues relating to him with IDAC inter alia. But it's not only IDAC, it was the PKTT itself that was involved in the recording that my client is referred to. And maybe also just to correct that, what was placed on record then, please, I'm not making myself a witness, it's recorded in court. In other words, it's something that can be dealt with here. It was placed on record that the subject of what is contained in these recordings are being investigated. And the inference that I would draw from that thinking back was that the PKTT and their cohorts are busy investigating issues that forms part of this interview that was, or the statement that my client was made to do. But again, as I said, I want to emphasize, we are going to address legal points to you on that in due course as part of the supplementary and on the points eliminated.
And not just the legal issues, but also the pertinent factual question whether there is any investigation relating to the alleged delivery of impalas to General Sibia by Mr. Matlala.
Indeed, as I've indicated
So
to you,
that factual issue, whether there is, because otherwise the privilege of self-incrimination will be a non-starter. So that should be addressed specifically
Chairperson.
as a factual issue, yes.
Chairperson, where I started off this morning, you will recall I said that when we deal with these issues, we have to deal with it on a factual basis and on a legal basis. You cannot have a legal argument in abstracto. It needs to be supported by factual issues. Thank you.
Thank you.
Thank you, Chair. Then for my own edification, where we land is, Mr. Matlala, when you deal in your supplementary with the issue raised in paragraph 2.3.2, you will definitively state whether or not there is ongoing investigation in respect of the impalas, and then you deal with the issue of impalas the best as you can.
Yes.
And who is conducting such an investigation?
Is the, what is it called, GCI Ops, GCI Ops, Gauteng Counterintelligence Operations.
Well, these are matters you'll confirm in your supplementary because it is important. Once you say there are investigations, then it presupposes that you know who is conducting the
Yes, yes.
So you will
Yes,
state that fact in your supplementary. Thank you. We then turn to item 2.
Sorry,
Yes,
Ms.
ma'am.
Lo, before you step off, just so that nothing falls between the cracks, that paragraph 2.3.2 speaks to it raises two questions. There's the impala delivery and there's any gratification, any other gratification. So I'm assuming that you adopt the same posture in respect of any other gratifications and that you will then deal with it in your supplementary affidavit as well.
Yes.
Okay, thank you. Thanks, Mr.
Thank you, Commissioner. That then brings us to the question set out in paragraph 2.3.3, and this required you to speak to the circumstances in which Sergeant Fanny Nkosi came into possession of the Luxor Africa Bank card. You were required to list all the periods when he had possession of the card and what, when, and for what he used this card. This you deal with at your page, starting at the bottom of page 13, where you have a heading at paragraph 2.3.3. And you deal with the Luxor Africa brand card at paragraph 16. So if you could take it from there.
Lux of Africa brand is my co-accused in the Medicare tender matter, and as such, I'm unable to respond to the question posed on the paragraph under reply. I'm of the view that I might incriminate myself by answering questions related to Nkosi and Lux of Africa in view of the pending case before the Specialized Commercial Crimes Court.
On that score, then if we, just so we always know what we are dealing with, is this the case you reference at paragraph 7.2 of your statement at page 9? Is that the Specialized Crimes Court, Commercial Crimes Court case? If you could go to page 9.
Yes, yeah,
It is.
Yes.
Then if you go still to, staying with page 9, paragraph 7.2, you recall we discussed the companies, your companies, through which you participated in the security services sector and the health sector. And we had identified Medicare 2420, PTY Limited, which you referenced at paragraph 7.2. At 8, you introduced CAT Protection and Security Services Trading as CAT VIP. That's in the security industry. And the third is what the company you referenced at paragraph 9 that you, I think you named Black AK.
Black
Yes.
AK Trading
Black
and
AK
Supplies.
Trading and Suppliers, which you say you established in 28. So those are the 3 companies we earlier in the morning established. You participated in the 2 sectors. Against that understanding, are you able to highlight what is the relevance then of firstly Luxo Africa brand and what your association with that particular company is for purposes of the health sector or the security sector as you had testified?
No, this company, it didn't have any relation with any government entity at all.
Yes.
So the funds that I've been transferring funds from my Medicare account to this company.
Okay.
And so this company has been charged with money laundering because they've been following all the monies that been coming from the SAPS tender.
Yes.
So this is how this company ended up being my co-accused.
I understand.
So the statement is no longer being projected.
Thank you, Chair. Apologies, went on the blink for a second there. Now, the rank, Mr. Nkosi, Sergeant Nkosi. Sergeant Nkosi is not an accused in the case you reference here, is he?
No, he's not.
He's not. And the question related not to the inflow of funds into the Luxo Africa Bank account, which you've just explained, that it came from Medicare, the Medicare account. It is the outflow by Sergeant Nkosi. How does that potentially impact the criminal case?
Because now I'm mentioning my co-accused, which I also, Lots of Africa is my co-accused in
Yes.
this. So the money that went to Sergeant Nkosi is from Lots of Africa. So I do not want to do that because now I still have to ventilate this in court. This Lots of Africa funds, how did they end up into Mr. Nkosi's account?
I understood you to say that the issue really is because it's Medicare 24 and it's Luxco receiving funds from Medicare 24. Perhaps if I ask, are those the only funds that Luxco has received in its account in the period of its existence?
Not that I can think of.
So there might be other sources.
Yes. It cannot be, yeah.
So if there are other sources, Sergeant Nkosi could potentially have been drawing from the other sources that are untainted by the Medicare funds. Again, I struggle to understand how then would that be relevant for the Medicare 24 case? Because this is the spending by Sergeant Nkosi.
It is relevant because it's something which is in the docket. And then it's something which I need to, in court, see how to defend and challenge those charges. It's in the docket, so to speak, and then luckily I even have the disclosure of the docket.
Okay.
I can share it with the commission and see that it is there.
Perhaps then, because I just want to understand and draw a distinction between Luxco as a recipient and Sergeant Nkosi spending the money
Yes.
and sources of funds into that particular bank account. Is it possible then in dealing that we request in your supplementary statement to deal further with the issues that you raise in paragraph 16 and to set out in the supplementary statement regard being heard to the question as to your counsel who, and I believe she'll be assisting you with this, if you can specifically address the question of how section 35 extends to the question posed at paragraph 2.3.3 in respect of Sergeant Nkosi utilizing the funds of Luxo Africa Bank. Chair, I saw your microphone on. I thought you wanted to say something.
Thank you, thank you. Mr. Matlala, a few minutes back you said, open quote, "it is in the docket," close quote. What I want to know is what exactly are you referring to? What is in the docket? Is it matters relating to Sergeant Nkosi and the transactions he made on the Luxo account? What exactly did you mean when you said it is in the docket?
I was referring to the Lux of Africa company, that it is part of the, it's part of my co-accused, and it is in the docket. Because the commissioner was asking me that how is it possible that Lux of Africa is not Medicare 24, then why is it also charged with this offense? So I wanted to maybe give her proof that it is in the docket, because of I have proof of that, and then it is also my co-accused. And then I do not want to prejudice my co-accused.
So in the docket, is there anything about the transactions made by Sergeant Nkosi?
I think so. I'm not sure, but during the interview they've mentioned, but I don't know whether they've included in the docket, because I haven't seen the contents of the docket yet, but I know there's a disclosure. But
just a minute, please continue.
yes, but during the interview he's been mentioned. I just don't know whether he is in the docket or not.
Yes.
Chairperson, just for the record, and I'm sure you know this, the content of such a docket is sub judice. We cannot disclose what's in the docket in public at this point because it relates to an ongoing investigation, of course. And statements, etc., that's contained in there, we will make ourselves culpable, and my client would, if he does so ahead of time, whilst there's a pending matter and where contents of the docket is subject to that pending matter.
I'm asking the question to understand the basis of Mr. Matlala asserting the privilege against self-incrimination. Because if there's nothing about that, it may well be that the privilege does not arise. I would be very surprised that the issue that you raise can ever preclude us from asking these sort of questions. I would be very surprised if that is what the law is.
Chairperson, that's why I've indicated to you we're going to deal factually with these issues before you. I do understand that you have a right to ask questions. We've never disputed that right to ask the questions.
In the interest of time, may I make this suggestion? Ms. Silo, I hope both you and Ms. Van den Heever will agree to this. Let us leave this Luxo question and let us see what the supplementary affidavit will say, and in particular about the issues that we have specifically raised. But of course, we would want to hear more and the full basis on which the right against self-incrimination is being asserted. Let us leave it at that.
Of course, Chair.
Thank you, Chair. Staying then, Mr. Matlala, with the notice, we then move to paragraph 2.3.4 in the notice, and that required you to speak to the loan or funding agreement entered into with Mr. Suleiman Karim or any of his companies in or about June 2022 or any other date, including requesting you to provide a copy of such agreement and that you speak to the terms of such agreement.
Did you say 2022 or did I
2024.
Apologies.
June 2024, that's the correct date. That is what is understood to be the date of the conclusion of this loan agreement. So that was the request to you at paragraph 2.3.4. You deal with that at your page 14 at paragraph 17. So if you could read that perhaps into the record. Thank you.
The loan agreement referred to herein is part of an ongoing criminal matter, and as such, I'm unable to respond to the question posed on the paragraph under reply. I'm of the view that I may incriminate myself by answering questions related to this loan agreement, as I believe it forms part of the Medicaid criminal matter which is pending before court. I was advised that there is a financial investigation being carried out with respect to all monies paid by SAPS into Medicaid and any transaction made in general within Medicaid bank accounts, and it is for this reason that I do not wish to incriminate myself.
If I understand your paragraph 17, your paragraph 17 correctly, the investigation relates to monies paid by SAPS. You state as such at your paragraph 17, right? That's what the investigation is about.
Yes.
Now, then it is safe to conclude that any funding and loans received from Mr. Karim in terms of a loan agreement does not constitute monies paid by SAPS.
It is.
Mr. Karim is SAPS.
No, not
Okay.
paid by SAPS, because I was paying the money back to Mr. Karim from the monies paid by SAPS.
So it says the investigation is into monies paid by SAPS into Medicare, and you say that that investigation extends to payments you would have made out of the funds in Medicare to
Yes,
pay
yes.
the loan.
Yes.
Okay. Now, the question relates to your receipt of the loan, not how the loan was treated thereafter. The question is very specific and requests you to provide the funding agreement concluded with Mr. Suleiman Karim. Are you able to provide us with that?
I cannot provide with that because it's a matter that is is in court, and then the purpose of the loan was because of to fund the Medicaid contract, and that contract is something which is now in court.
I appreciate that, and you explained earlier that the investigation into monies paid by SAPS into Medicare, extends to payments by Medicare to inter alia Mr. Karim in settlement of the loan. That's what I understood you to say.
Yes, that's correct.
Now, I say the question requested you to provide the agreement with Mr. Karim or any of his companies that you may have concluded on the date specified and the terms thereof. So it's the terms of the agreement that the Commission is interested in at the moment.
The terms of the agreement only.
The loan agreement, yeah. The loan agreement, or one, if there's one.
Yes, but the loan agreement has to do with the Medicare contract.
Okay. Now, at least we've established there is a loan and there's a loan agreement. Is it in writing or oral?
It was oral.
It was oral.
Yes.
The date suggested there is June 2024 or thereabouts. Do you confirm that date?
Chairperson, I don't understand. The client has asserted his rights on that particular issue. And just for the record, my learned friend should know that in her investigation of these matters, more specifically the Medicare 24 contract, doesn't only relate to a tender that was awarded. There's issues under PRECA, there's issues under POCA that forms part of that particular matter. To try and simplify it with a non-legal person by saying it only relates to money coming from SAPS is pure and simply just not correct.
If I may, Chair, I was addressing myself to the manner in which Mr. Matlala elected to express himself. He invoked his rights where investigations are underway, and he indicates in the statement that the further investigations he's aware of are in respect of monies paid by SAPS into Medicare. That's what he's got written. He expounded on that to indicate, including monies paid by Medicare back to, let's say, would-be entities that loaned the funds. Now, those are matters I think we will still engage on and debate on an argument with Ms. van der Heever. What I asked about and reminded Mr. Matlala about paragraph 2.3.4, it concerned itself only with the loan agreement, the terms of the loan agreement with Mr. Karim. If Ms. van der Heever wants to argue that because of the nature of other charges that I'm not aware of that invoke PRECA and related legislation, that he should not be required to speak to such agreements, then I would invite in supplementation that that matter be dealt with in detail to specify the particular sections and the crimes for which Mr. Matlala is charged, in respect of which he concluded an agreement with any third party that is not an accused before court at this current moment.
I will do so, Chair.
Thank you.
Thank you, Chair.
And I would imagine this is still going to arise with regard to other issues that are still to come, and that is a function of the fact that the privilege is being asserted in very broad and generalized terms. So perhaps the solution should be, not that we're not going to raise the issues. I'm not suggesting you should not ask the questions, Ms. Sillo. No, am I suggesting that my co-commissioners should not ask the questions? I'm just saying we are likely to encounter this a good few times until we are done with a statement, and perhaps the solution in respect of all is for us to get a clear substantiation of the full basis, its inner and outer contours of why the privilege is being asserted. It's only then that we will all be in a position to engage with the privilege as substantiated. But please continue.
Indeed, Chair, I'm in full agreement, and I think the purpose of this exercise was to understand the extent to which this privilege is being asserted. Is it in respect of anything that even is remotely related to the Medicare contract, whether or not it's the subject of any criminal charge or investigation? Because the line we seem to be holding thus far is any reference to anything in this where Medicare 24 contract is referred to is subject to Section 35. So I think it was necessary it is necessary for Mr. Matlala and I to understand one another, and for him to appreciate that we need an understanding of when it is this right is asserted and the basis thereof in regard to the specific questions that are asked. So unfortunately, it's an exercise we're going to have to go through in respect of each, and he keeps undertaking that when he files his supplementary statement, he will address each question specifically in response where he asserts this right. Thank you, Chair. Then, Mr. Matlala, that leads us to your paragraph 2.3.5. We are now in the, not yours, paragraph 2.3.5 of the regulation 10.6, if you could turn your attention to that. That paragraph is at page 4. That paragraph requested you to speak to your appearance at the ad hoc committee, that's a parliamentary ad hoc committee, and whether you were induced or threatened or influenced to give false evidence.
Can make my supplementary